Are you a puppet on a string because you are bound by an existing contract of inheritance? May you make gifts despite an existing contract of succession? What did you agree at the time? As of January 1st, 2023, according to the revised Swiss law of succession, there is a new fundamental ban on inter vivos gifts. Have you become a non-suspected puppet? Please watch this video to learn more about this subject. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If this video appeals to you, then like it and forward it to someone else. A testator may, by contract of inheritance, make binding instructions about his estate. For example, he undertakes to another person to bequeath his estate or a legacy to that person or to a third party. In the past, you could freely dispose of your assets. In other words, there was a general exemption for making gifts during the lifetime of the deceased, except for gifts made abusively and gifts made with obvious intent to harm. After your death, there was some risk of challenge. Now, respectively after January 1st, 2023, a fundamental ban on inter vivos gifts applies, except for customary occasional gifts and reservations. The beneficiary of an inheritance contract is now better protected, while a testator is restricted. Yes, you heard right. A prohibition on gift and donations restricts you. Do not let yourself be forced into a corset, nor become a puppet on a string. Provide for clear reservation clauses, modification and gift reservations. What is incompatible with obligations under the contract of succession must be stipulated. Without an express reservation of the right to make lifetime gifts and or to make testamentary dispositions, you risk a challenge on the ground that the inheritance contract is incompatible and thus breaking the peace within the family. For example, should gifts be possible, and if so, to which extent or in what amount? Should the testator be allowed to make bequests or be able to react to changing situations and reduce contractual legacies? The party's will is decisive. Again, pay attention to explicit reservations. With gift reservation, you have the right to make gifts during your lifetime. With explicit reservation of modifications, you may be able to make bequests. A challenge should not be possible. However, we do not know how the case law will develop. Only time will tell whether there will be limits on reservations, whether the all-round fundamental ban on gifts will remain in place, or whether different criteria will be applied. Apart from this, until the moment of death, it's really not clear whether there will be any assets left at all. It may disappear in a flash. Wealth may melt like a glacier, elderly erode assets. Thus, the party to the contract of succession may inherit an over-indebted estate. I would like to point out that gifts, whether pure or mixed, are generally tricky. They may lead to unequal treatment of heirs and to a violation of the statutory share. Only when the donor dies, the value of the gift or donation can be determined. A house that was transferred to you 15 years ago, for example, is worth much more today than it was then. Are you surprised? According to transitional law, the new law applies to existing inheritance contracts. What can you do if you, as the testator, have unsuspectingly become a puppet? If all parties involved are alive, the contract can be revoked if necessary, with the written consent of all parties involved. Subsequently, the same parties agree on a new inheritance contract to be publicly notarized, with explicit reservations. May I draw your attention to pending divorce proceedings? From January 1st, 2023 on, unless there is an instruction to the contrary, a spouse or a registered partner may not raise any claims based on a testamentary disposition, for instance, a contract of succession or will, after the death of a spouse or partner during pending divorce or dissolution proceedings that result in the avoidance of the forced heirship of the surviving partner. Have you entered the contract of inheritance? What did you agree on? Who is a party to the contract of succession? Let us check together whether your existing inheritance contract is compatible with the new inheritance law. There is no transitional legislation. I look forward to supporting you, fulfilling your personal and last wishes to have a peaceful distribution of your assets. Please contact me for a consultation.